order. We're going to get our meeting started. Okay, on the agenda today, we have three bills. House Bill 109, House Bill 229, House Bill 263. I'm going to be taking those up in reverse order. So with that, Representative Scoggins.
Thank you, Mr. Chair. Ladies and gentlemen, I bring to you House Bill 263, and this relates to the probate judge's retirement fund. And all this does is make a little change in the amount of benefits that a spouse could draw from her husband or from her wife who was a probate judge, and changes the amount. We were operating under a measure that had been used since 1951, and we're just trying to bring it up to date with all the other retirement funds like the state retirement funds and the other retirement funds across the state. And I have Bob Carter with me today. Bob is the manager of the probate judge's retirement fund, and I'm going to let him speak about the bill.
Representative Scoggins did a great job. All it does is lets us modernize the mortality tables. Every 3 to 5 years, our actuaries come to us and tell us, that there's been a new mortality table come up. So if we continue to use a 1951 table, we're cheating the people with the life longevity of a different world from 1951 and an different interest rate. So that's all it does, is let the board keep up those mortality tables as they progress during the years. It doesn't change anything we do or how we do it, just those little actuarial numbers in there.
All right. Any questions by the committee?
We do have a letter from the Department of Audits and Accounts.
I was going to ask you, is there any fiscal impact on the state?
No, none at all. None on the fund even.
Okay. Any questions? Any on Zoom? Yes, sir. Well, you're number 12. There you go.
And this is more just for my illumination. So the section 2, it says it's effective only if it's determined to have been concurrently funded as provided in a certain section. Otherwise, it shall not become effective. That's just new to me. I was just wondering what sort of the background of that is, or why that's in there. And
Mr. Chairman, if I may.
You may.
Because this normally would have gone to retirement committee, all the bills that go through retirement committee has that paragraph in there, because most of the time they have a physical impact on a retirement fund. And when it does, but this one does not. It's just something that legislative council is accustomed to putting in retirement bills.
Okay, so it's a standard thing that goes on.
Just
all the
standard,
time. Okay.
standard lingo.
What's your number? 7?
Number 7.
All right.
Thank you, Mr. Chairman. I was just curious if previously we were looking at using the group annuity table for 1951 at a 5.5% interest. What right now is the current interest rate provided under the current and accurate mortality table adopted by the board? What would that interest rate be?
Ma'am,
Yes, sir.
it's about 3.5%. And they actually have a new mortality table now for government employees, which is something that's new as of last year. So the actuary and the state auditor recommended that we update this. There's some funds out in California that have been sued for not updating their mortality tables.
Makes sense. Thank you so much. Just curious. Good
Yes.
deal. Proper time, Mr. Chairman.
All right. Any other questions? Any on Zoom? We're done? All right. I'll entertain a motion. All right, we have a motion to pass. Do we have a second? Have a second? Any further discussion? And no amendments, I take it? All right. All those in favor, say aye.
Aye.
Any opposed? Hearing none? Nothing on Zoom? All right. Bill passes.
All right, thank you.
All right. At this time, we'll call Representative Carpenter up for House Bill 229. I believe you have a committee substitute.
Yep. We're working off of LC 36 4594S.
All right. All right, whenever you're ready.
All right, thank you. Ladies and gentlemen, you have before you House Bill 229, which is an opportunity to protect Georgia consumers and to protect Georgia small businesses. At the issue here is the 30% payment processing fee charged by the two entities that control 99% of the app market. I fell in love with this issue personally because of issues that I've seen in the past year and a half. One, I'm a big fan of music streaming services. I have a Spotify on my phone. And I noticed about a year and a half ago that the price of my streaming went from $10 to $14. And so I did a little research and I found out because Apple and Google charge 30% for payment processing, Spotify had to increase their what they charge me. And I went on and further researched it and saw where Apple was actually charging only 10 for their music streaming service. So I found that a little bit of an unfair competitive advantage that Apple had because they weren't charging themselves the same fee that they were charging Spotify. The second issue came this fall. I have two children and they love Fortnite. They play it constantly this fall. And so I noticed where they came to me and they said, Dad, my Fortnite's not working on my phone. What's going on? So I did a little research and I found out Fortnite sells skins for most of you folks that don't play Fortnite. That's uniforms that you wear when you're playing the game. So my character, if I wanted to wear a Falcons jersey, I could pay $1 for it's probably half price because it's a Falcons jersey, but I could pay $1 for that uniform and my character would wear that skin in the game. So Fortnite decided that because they were driving traffic to their game on their own, not Apple was not driving that traffic, they would sell skins outside of their app for $1, keeping 97 cents for that skin and allow players to import that into the app. Well, when Apple caught wind of this and Google caught wind of this, they shut it down and they took them off the App Store. So I thought, maybe this issue needs to be addressed a little bit more. So I'm going to go through the bill real quick. I know it's early and I know you got a lot in front of you, but basically this bill, the first part is pretty simple. You've got an app developer and you've got an app platform, a digital distribution platform. The platform would be Apple and Google because they control 99% of it. And then the app producers in my world would be Spotify, Fortnite, other games that are out there and whatnot. You have an in-application payment system. So currently what it goes, Apple, if you're selling digital apps, if you have a digital app, any money collected has to go through Apple and Google. They keep the 30 cents on, and then they send you the 70 cents on $1 purchase. They don't do that for all their apps. Like Uber's allowed to process their own payments. Amazon's allowed to process their own payments. But for some reason, because they have a captive audience and they've got the digital developers held hostage, they keep that at 30% and they don't give them the option. Number 4 is a special purchase application platform. And what that would be like your Xbox, where they do, there's apps and whatnot for your Xbox and digital downloads for your Xbox. All right. And so what this would require a developer to, a proprietary application platform that sells such digital application platform in this to residents in this state, should not require a developer to use their only payment processor. It would also keep them from retaliating against the developer for choosing a different payment processor. It would not allow them to impose restrictions on the developer for communicating with its customers through the app, because we're seeing some of that. And it would also allow, it would not allow them to place their apps above the other apps or put their apps at higher ranking than other apps that are on their platform. So what you have is a scenario where Apple Music, if you pulled up music, Apple Music would be a higher on the list than Spotify Music. So it's not based on usage or, rating. It's literally they're placing their apps above other apps on that platform. And so at the end of the day, you've got a situation where you've got a monopoly on the app, on the platform, on the app platforms. And this is a chance to protect not only small business development, but also give the consumers, because we're all paying 30% more for apps than we should at the end of the day. We've got 2 speakers on this bill. The first one would be Brandon Crescent, an attorney for the Coalition of App Fairness.
All right. Are there any questions for the author?
Or I'll take any questions. Sorry.
I have a question.
All right, what you got?
This does not change the software or anything for these apps. In other words, and I'm not real familiar with this.
Sure.
At my age, this is something I don't really mess with a whole lot. But if you develop this software and you want to get into this platform, I guess there's certain rules about the kind of software you have.
That's right. And so, yeah, this bill addresses that issue. So it says basically, they can't tell an app they can't be on their platform other than, level of security and a level of professionalism, if you will, in that app. So it does address that issue and say, look, they can still tell you your app is not worth being on Google, on the App Store, on the Apple App Store at the end of the day. So there is a piece in there that allows them to keep bad players off their platform.
Okay, all right. That's what I was curious about. All right, I've got some questions now. Representative Reeves.
Thank you, Mr. Chairman. This question might be better. You said that there's an attorney for
Oh, yes.
the association that's gonna,
Yeah.
This might be a better question for him, but I'm not super sophisticated in a lot of this tech discussion stuff, but this seems like something that federal law should probably be controlling on at some point. And can you walk me through? And if you can't, that's fine. I understand. And I'll ask the same question to the lawyer, but how does federal law play a role into this?
So you're not seeing a lot at the federal level at this point, like the marijuana issue, other issues that the feds refuse to lead on. I think that it's going to require states to address the issue so that the feds will take up the issue. You're seeing a lot of action and momentum on this in the EU right now. There's all kinds of things going on for consumer protection over there, but unfortunately, our federal government, like most issues, are slow to move on.
As far as it be, I mean, I see this, I understand this is a complex issue and there's multiple layers of considerations here, but just kind of fundamentally, it seems like that we've got a contract issue. I mean, there's contracts that underlie all of this, and how does this? I mean, you have prior agreements between Apple and Google and these apps. I don't know the terms of those contracts or how long those contracts go out for, but doesn't this essentially kind of get us to a place where we're undermining some aspects of contract law?
Yeah, there's absolutely. I mean, that's absolutely what's going on. But unfortunately, you've got a situation where you've got two players that have a monopoly on something, and the contracts are completely one-sided.
So if it is a monopoly, then again, I think part of it is I'm trying to understand the federal implications of this. If this is to be looked at through the spectrum of a monopoly, then it seems like there should be some kind of controlling federal issue here. And again, I'll ask that question to the other speaker.
Yeah, and I understand your concern. I think the biggest thing for us as Georgian is what do we do to protect Georgian consumers, right? And so if I'm paying 30% more for something, I would hope that my state government would step in and say, wait a minute, we need to evaluate this and see what's out of whack right here. I mean, we do it every day with electricity and everything else. So why would we not evaluate something that people use on a daily basis when there's unfair treatment of Georgia consumers?
And so with the other state, you said a second ago, talking about other states and that the states need to take an active role in this. Let me kind of back up from a more elementary standpoint. Is the fee structure that we have, the 30 cents on the dollar for in-app purchases or whatever it's called, is that across the country, or is that how it works in Georgia?
No, it's across the country.
So
Yep.
have other states
There's other states taking up this issue as well right now.
is anybody ahead of us on that?
I mean, I think everybody's on the same boat rowing right now, and Georgians love to be first.
Is this the legislation that's presented here, is this uniform with what's being considered across the country, or?
Yeah, I think so. I think that you've seen some class action language in others, but we took that out of this bill because I'm not a big fan of class action.
Okay, Mr. Chairman, I don't have any other questions right now.
I'm struggling also here, Mr. Chairman. And I was gonna wait to hear from the speakers who I think may be able to explain it to me. But it's clear to me, and something I really don't understand, that this is a huge business dispute. And I'm trying to figure out who the business entities are. I know it's Google and Apple over here, but I don't know who's bringing this bill over here. So I'm trying to figure out who the competitors are here, who are in a Wild West competitive arena. And
So it would be app developers. So if you're anybody that develops Candy Crush, you ever seen that little game that everybody plays? It's all those people that are developing these apps that are getting charged this exorbitant fee.
big players there too.
Oh yeah, absolutely. But there's a lot of small players. So we've got it's a growing industry. The gaming industry especially is growing in Georgia. And I just find it really hard to believe that it takes 30 cents on a dollar to protect your privacy and to process your payment, because with fintech being such a big industry in Georgia, I mean, we process millions of websites every day, process stuff on the internet for 3% and protect your data. So why does it take 30%?
Sound like the conservative Republican here.
Yeah.
Wandering into this huge business competitive arena, when I don't understand it, makes me really nervous.
Yeah.
Maybe these other people can explain it.
Yeah, I can understand that. That must have came when she got the chairmanship. She's coming over, boys. Keep an eye on her.
But I'd be happy to debate for about 45 minutes why Georgia Power is not in this arena.
Yeah.
I mean, you can't make this like electricity, but we'll just skip right over that.
I don't know.
All right, Representative Wilson.
Representative, does this bill not push us into major ongoing litigation right now?
There is litigation going on, yes, but maybe not so much if from a consumer protection part. I do believe. The issue is contract. The litigation. This is more of a consumer protection part.
Well, I just know that this committee in the past has been wary of wading into legal disputes that are ongoing when the courts are currently looking at the issue. You addressed the class action being removed. I'm just curious, was that just a personal preference or
no?
some other
I
reason?
think there was some heartburn on both sides of the issue, and when you start throwing class action out there.
Okay. And earlier you were using, I'm sorry, there's feedback, but
It's the double mask.
earlier, but zero COVID. Earlier you used the word monopoly a couple times, but this isn't really a monopoly, right? Because even though Apple Apple and Google have two of the biggest markets, they're not the only markets, though, right? Samsung has a market, Amazon has a market, Xbox has a market.
Yeah, but I think it's 99% of the market. So I think you could assume. I think Microsoft has a pretty good play in this, and they would agree that we have an app fairness issue. So I think a lot of the other players could agree to it. It's the 99% that aren't agreeing to it, that control it. Because I mean, let's look at our phone. We can choose AT&T or we can choose T-Mobile, but when it comes to app stores, we don't have a choice. It is Apple on an Apple phone or Google on an Android at the end of the day. And I think the major issue with that is, your phone, we're paying $900 for a phone that doesn't cost that much to produce, but you see the other stores, if you're buying an Xbox, they have a lot more in that machine. They're almost selling that machine at a loss. So I think that's another big issue is Apple's making money on the front side and on the back side. Mm-hmm. And I'm not against people making money. Don't get me wrong. But at the end of the day, when they're limiting options, I start having a problem. And I think consumer protection is a bipartisan issue.
So talking about consumers, if this bill were to go into effect, would Georgia consumers not be segregated out from, assuming no other state passes this bill, we're the only one, or we're the first one, Georgia consumers would have to be segregated out from the rest of the online market, right?
Yeah, absolutely. But we see geofencing all the time. I mean, when I'm in Georgia and I'm playing DraftKings, I can play college football, but when I drive to Chattanooga 20 minutes north, I can't play college football. So I don't think that's as big as an issue as you would think. The geofencing make it really simple. And it would allow, I think at the end of the day, this fee stifles innovation. You know, you start taking 30 cents on every dollar out of an app developer's pocket, then it keeps people from, you know, it makes it less attractive and cuts down on, you know, maybe having a whole lot more apps out there at the end of the day.
Okay. 12. Rob, go ahead.
Thank you, Mr. Chairman. I had one question here just about some language in the bill, and then I had another question to make sure I sort of understand the context. Let me do the question about the bill on the, at the end of section 1, page 3, line 61, 62. Subsection E, the code section shall not apply to a proprietor of a special purpose digital application distribution platform. Explain to the old guy what that means.
So that's that Xbox scenario I was telling you about, where basically Xbox, they do charge higher fees for their processing on Xbox, but a lot of that is because they're not making money on that Xbox machine itself. And so that's the delineation, is saying, look, I understand you have to charge more when you're not making money on the front side, but when you're making a lot of money on the front side and you're making a lot of money on the back side, you know, it's like you're double dipping on the Georgia consumer.
Okay, thank you. And now let me just make sure I understand. We've talked about people in a competitive marketplace, but my understanding, just from a brief discussion we had prior to the actual committee convening the meeting, was that this is not so much addressed at what the fee is set at. It's addressed at prohibiting one of these developers from using an alternative platform to do something, to either charge for like the uniforms or to whatever. It's more addressed at the Googles and the Apples of the world, the digital application distribution platform managers, from treating the developers differently than the platform treats its own software.
Yeah, that's right. That's a piece of it, but it's also basically, going back to your first question, they go off if they go off the platform to collect that revenue, they pay, of course, a whole lot less money to collect that revenue. But when they do that, then Apple and Google shut them down. So it's not allowing them to do that, and that's part of the major issue. And then there's other issues in there, of course, about moving their apps in front of other apps, using their data, and people using a particular app to create their own app. So I mean, there's a lot more to that piece, but you know, the major piece is the actual collection of the fees and not allowing competition.
So does it purport to restrict the fee charged?
No, it just says allow there to be third-party processors. So, I mean, competition will then
You'll bring
restrict.
competition.
Correct. And competition will drive down those, because we all know it doesn't take 30 cents to process a credit card.
And then they can't retaliate against the developer, to use the term.
Correct.
For going off the farm to collect that revenue or sell.
That's right. So you'll have Fortnite. If this bill passes, Fortnite will be back on your iPhone.
Okay.
If that matters to you.
Well, to the 56-year-old guy, that's kind of irrelevant, but I appreciate that.
All right. Thank you. Who else we got?
I have a question, Mr. Chair.
Oh, I'm sorry.
Thank you, Mr. Chairman. I know we're trying to move forward, but I just had a couple quick questions. So first, looking through the bill, I just want to make sure I'm clear about the mechanism of enforcement. Should we pass it? Is any litigation that'll be brought just in line with everything else in the Fair Business Practice Act, or do we think we ought to have a specific provision for either civil, for civil penalties here?
I mean, that's y'all's call here, but yeah, I mean, I would fall under that Fair Practices Act.
And then just a few more questions, if I can, Mr. Chairman. Aren't there other instances in Georgia law where we do lay out terms and conditions and contracts? I think about usury laws. I think about lemon laws for car dealers. So aren't there other areas in Georgia law where we regulate contracts?
Absolutely.
And I know we've got into a conversation about whether this is a federal or a state issue. And I always try to, being that conservative Republican like my friend Chairman Oliver, I like to focus on state law best I can. And isn't it true that contract law is generally regulated at the state level?
That's correct.
And then finally, I've heard a lot of conversation about the impact this could have on economic development in our state. Do you think that should we pass a piece of legislation like this could help bring new, innovative technology companies that would want to develop apps in our state here to Georgia?
Absolutely. It's not only that piece, but also the fintech industry is their opportunity to be able to get involved in this $50 billion arena is a big boon for Georgia companies as well.
Thank you, Mr. Chairman. No further questions.
Representative Reeves.
Thank you, Mr. Chairman. I know that we've talked about Apple and Google taking the 30 cents on the dollar. What's the fee that the other providers, the Samsungs and the Amazons and whatnot, are they taking a similar fee, or is it substantially less?
So I know that the fee is very similar on the Xbox, and I know that Microsoft is real interested in moving towards this 3%, 3 to 4% fee. I'm not sure on the Amazons of the world, but I can get that back to you for sure.
Samsung, Amazon, et cetera.
Yeah, I'll check it out.
It would just be good for comparison purposes to have an idea of what the range is. We seem to be a lot of the discussion seems to be about Apple and Google, and while I understand they may be a vast majority of the platform here, but I think that we should get an understanding of what that smaller percentage of what the details of their terms are as well.
Sure. Yeah, absolutely.
All right, go ahead.
I just want to make sure I'm not missing something in the bill. We're not anywhere in the bill dictating what the maximum rate they can charge. We're just saying that they can't prohibit other download opportunities onto their devices, correct?
Yeah, that's correct. So
Okay.
yeah,
So we're not actually telling them what they can charge, what they can't charge. We're just saying we're going to open it up to the market. We're going to allow, if I wanted to start a digital distribution platform and I wanted to host you as a developer on it, someone would be able to come to my platform and download it onto one of their devices.
That's correct.
Okay. Just making sure. Thank you.
Anyone else? None on Zoom. All right.
Yeah. Brandon Crescent, attorney for the Coalition for App Fairness.
All right, is he here? He's on Zoom. Where do you have that? Okay. All right, Mr. Crescent, I think we're ready for you.
All right, thank you. And thank you to Representative Carpenter. And thank you to the committee for providing me with the opportunity to speak with you today. My name is Brandon Crescent, and I'm here on behalf of my client, the Coalition for App Fairness, to speak in favor of HB 229. I'm an experienced antitrust lawyer with a specific focus on the technology industry, including issues involving mobile platforms and app distribution and monetization. The Coalition for App Fairness is an independent nonprofit organization made up of industry-leading app developers. And these developers have come together to advocate for freedom of choice and competition across platforms. The coalition's members are committed to the creation of a competitive system for the distribution and monetization of apps on the major platforms. Their vision for that system is set out in their App Store principles, which is a list of rights, responsibilities for app developers that would restore and preserve competition on mobile platforms. HB 229 will benefit consumers and app developers in Georgia by limiting the ability of the dominant platforms to continue imposing onerous and anti-competitive practices on developers. These restrictions result in higher prices and less choice for consumers and less ability for developers to deliver innovations. If passed, HB 229 will enable app developers to offer lower prices, greater innovation, and more choice to smartphone users throughout Georgia. Now, it's often said that no other technology has had as big an impact on our lives over the last decade as our smartphones, but we think that tells only part of the story. On their own, smartphones are just expensive rectangular phones with touch screens and slick edges and a few default apps. What makes smartphones revolutionary is not their hardware, it's the apps that run on them. And independent entrepreneurial software developers have experimented and innovated to invent those new apps and services, which change the way we interact with our world and with one another. In doing so, these developers have created incalculable value for consumers and also eye-popping profits for the owners of the dominant mobile platforms. But over the course of the last few years, the dominant platforms have increasingly imposed a wide range of onerous and exclusionary restrictions on app developers. They often impose these restrictions without warning and with, at most, pretextual justifications, justifications that the platforms could otherwise achieve through less restrictive alternatives. And when developers resist, as in the case of Epic Games, the platforms often threaten to expel the developers from the app stores altogether, a penalty that would devastate almost any app developer, regardless of their size or reputation. The platform's Byzantine restrictions take many forms. In some cases, the restrictions impede the ability of independent developers to offer apps and services that compete with the platform's own apps. In other cases, the platforms have used their app stores as weapons to intimidate developers, as in the case of Apple recently expelling Fortnite from its app store when Epic Games chose to defy Apple and offer customers a lower price if they use an alternative payment system other than Apple's expensive offering. And perhaps the most egregious example of abusive overreach is the way the dominant platforms seek to control how developers engage with customers and process payments. Developers who offer quote unquote digital products and services have no choice but to use the platform's proprietary payment systems exclusively. The platforms then extract an astronomical fee for that privilege. So just let me illustrate. Suppose I'm an independent developer and I want to offer a game, a podcast streaming app, or some other new digital service. And if I want to reach iPhone users, then I have to use Apple Pay as the exclusive means to process my in-app transactions. And when I want to sell digital products or functionality to users on the iPhone, Apple prohibits me from using PayPal or Square or another payment processor. Instead, I have to use Apple Pay and only Apple Pay, and then pay that exorbitant 30% commission, which is more than 6 times as much as I would normally pay for payment processing in other situations. And what do I get for that 30% fee? Well, Apple now owns my customer relationship. If a customer wants a refund or a cancellation or has a problem with their payment, I can't help them. I have to send them to Apple. And if one of my users switches from an iPhone to an Android, then they have to cancel their subscriptions on their iPhone and resubscribe to the same apps and services through their Android app, which creates new frictions to switching. So even when the platforms offer lower fees for certain developers, the terms they impose are harmful. For example, now that Apple is facing increased scrutiny, it is said it will lower fees for smaller companies with less than $1 million in revenue. But the fees it is charging are still multiples of what developers would pay in the competitive market. And Apple's fees create perverse incentives, such as the fact that developers would prefer to generate $999,000 in revenue rather than $1.1 million in order to qualify for the lower fee. In effect, these payment processing restrictions are a massive tax on developers and the developer ecosystem. And as we all know, when you tax something, you get less of it. In this case, what we're getting less of is app development. Fewer developers creating innovative new services, fewer entrepreneurs taking a chance on new app ideas, and those apps that do get created, the platform's tax means higher prices for consumers. In addition, we get less and less competition, and the dominant platforms are tightening their grip over the mobile ecosystem. This harms not only developers, but also consumers and Georgia consumers as well. What HB 229 does is begins to give some control back to the developers who build the apps and services that make our smartphones compelling. It opens up the platforms to competition between different app stores and competition between different payment processors. And that competition will mean app developers will have more freedom in how they engage with customers in Georgia. And if we pass HB 229, it will unlock innovation and lower prices. As is currently drafted, I'd like to note that HB 229 focuses on transactions and downloads involving smartphone users located in Georgia. This is a good start, but it may also be beneficial to extend the rights granted by this bill to protect any consumer that transacts with a developer based in Georgia. Right now, we're working with Legislative Counsel to ensure that such provisions don't raise any Commerce Clause issues, but if the bill can be amended in this way, then it would be another enormous boon for Georgia's technology sector, attracting companies and investment to the state. Finally, before closing my remarks, I'd like to briefly address some of the counter arguments I've heard from the platforms and their allies, and some of the questions I've heard today. what they argue is that the platforms need to retain control in order to protect the privacy of their users and the security of their operating systems. But these arguments are really just a smokescreen. If the platform's requirement that developers use their payment processing services was motivated by a concern for user privacy, then they would impose the same safeguard on all developers, but they don't do that. The dominant platforms don't impose any payment restrictions on other widely used apps like Amazon or Uber or DoorDash. I'm sure you've noticed if you use the Uber app that when you call up a Uber taxi, it gives you an option of using PayPal or credit card or Apple Pay. There's no particular reason to think that those apps are better stewards of privacy just because they offer quote unquote physical goods and services rather than digital goods and services. The distinction only makes sense when you understand that the platform's actual motivation is to leverage their market power over app developers who offer digital products and services to extract revenue and to insulate their platform's competitive pressure from competitive pressure. And finally, any claim that the platforms must either forbid other app stores or favor their own due to security concerns is similarly specious. We all have personal computers and Macs, which for decades now have allowed us to download and install software from different third-party sources. Users are more sophisticated now than ever, and they're capable of deciding which app stores offer the best mix of choice, security, and quality features. The platforms are going to be able to continue offering their app stores, but they're not going to be able to force the decision of consumers over which app store to use. We believe that competition is critical to preserving a free market economy. And the Coalition for App Developers, Coalition for App Fairness supports HB 229 because we believe that consumers, developers, businesses, and even the platforms themselves will all benefit from competition and freedom of choice. Thank you once again for giving me the chance to speak with you, and I look forward to answering your questions.
All right, questions for Mr. Kesson by Representative Reeves?
Thank you, Mr. Chairman. So you're representing the Coalition for App Fairness, is that right?
That's right.
Who are the members? Are you permitted to say who the members are of the coalition?
Yes, we actually have a website that lists our members. I believe there's more than 46 app developers listed on there. But these are the developers of a wide variety of apps. A lot of them, I believe most of them offering digital products and services. So the ones who are most affected by the platform's anti-competitive restrictions.
And I think one of the, as I said earlier, this is a very complex and frankly confusing issue, especially for people like myself who are just not real savvy with a lot of this kind of stuff. But and so what I'm trying to figure out, I believe that is my understanding that there is some level of litigation going on. I don't know if that I don't understand if that's at the federal level or at the state level. I'm not sure. I don't think that's been made clear. But what impact would this legislation, if it became law, what impact would it have on the pending litigation that's going on right now?
That's a great question. So the litigation that's ongoing right now is an antitrust claim under federal law. I believe the case is taking place in California. And what's at issue in that case is whether Apple has already violated the federal antitrust laws. This legislation is not retroactive. It doesn't state or it wouldn't lead to a conclusion that Apple or Google are currently violating the antitrust laws. It is simply saying that going forward, they're not allowed to impose restrictions on app developers and on their devices that say you can only use our store, or if you're a developer, you can only use our payment processor.
I want to go back. I had asked you a second ago about the apps that are members of the coalition. I think you said there was approximately 40 something developers. Is if there were 40 something developers, does that expand into more than 40 something apps? Or is it, or is each developer account for one specific app?
I believe many of the developers offer multiple apps. Some are small developers that may only offer one app. Some have multiple apps in multiple lines of business. Some have different brands in the same line of business.
And of the 40 something developers, how many of these are Georgia? I did that. We talked about this is obviously would be this legislation specific to this commerce in the state of Georgia. How many of those apps are Georgia based?
I actually don't have the exact number on that. I should have that, but I'd be happy to get that number and share it with you.
And I would definitely be interested in that information. And the last question I have is, I know that we've talked, and again, this is like learning a new language for me. I understand litigation, but the technology language is very foreign to me. And so with that, I know that we've made clear, we've identified that Apple and Google seem to be charging 30 cents on the dollar. Is that the standard rate for every single app, or does it depend on how big or how profitable revenue wise the app is? Is 30% the standard of what's paid? Is that what everybody pays, or is there a tiered amount? I mean, tell me how that works.
That's a very good question. So there's a few different ways that the payment gets broken down. One is the difference that I mentioned between physical goods and services and digital goods and services. So if you're Uber or you're Amazon or you're DoorDash and you offer a physical product, Apple doesn't require you to use its payment processing service. You can use, when the user logs in, they can choose to pay with PayPal or Square or some other payment processor. And because of that competition, the rates that get charged are much less than 5%. So we're talking about a subset of app developers, which are app developers who offer digital goods and services, which is still an enormous part of the market. In fact, I believe it's the biggest part of the market. Among those, Apple has recently, in light of the scrutiny that it's coming under, decided to reduce the fee that they'll charge for certain developers. I believe those who account for less than $1 million in revenue per year. And so they'll reduce the fee to 15%. I'll point out that 15% is still exorbitant, multiples of what they would pay if the market was competitive. And it only applies until that app actually gains a lot of success and starts generating enough revenue that it can turn into a real long-term business. And it disincentivizes them from doing so, because once you pass that $1 million threshold, that 30% tax applies to everything. Imagine if our income taxes worked that way. That you paid whatever your top rate was on all of your income. It would have very perverse incentives for how we work, how much we try to make money. The same is true for app developers who have to pay this Apple tax.
I'm trying to think by way of analogy here. I know that in retail real estate space, like location is everything, right? Whether you succeed or fail is based on, in large part, where you're located. And obviously you pay a premium for high level location. And am I wrong? And I may be thinking about this completely the wrong way, but by having your app be available on Google and Apple, then that's your location, right? I mean, it's available. Everybody out there if that's where 99% of the people are browsing or shopping or whatever the right language is, then there's value in that location. Is that right?
So I think is a good analogy, but I would say that what we're living in is a city where all the commercial real estate is owned by one developer, one realtor. And so the terms that they impose on the business are not determined by competition or the fair market value of what they're offering. It's determined by their market power and the leverage they have over everybody by virtue of their monopolistic power.
I mean, how many of these apps are going under and closing their business because the fees are untenable?
Well, there are certainly apps that have gone under as a result of losing their or the amount of money that they're having to pay. Another form of loss is the fact that apps aren't being made or aren't expanding. It's not an attractive market to invest into if you have to pay 30% of your revenue off the top before any other costs are taken into account. The stifling of innovation comes from the fact that you know that if you do succeed, a sizable share of the revenue is going to be going to Apple or the major platforms, and as a result, you're not going to be able to make enough to justify the investment.
I don't have any other questions.
Thank you. All right. Representative Kelly.
Thank you, Mr. Chairman. I guess I kind of got interested in the question we had about, real estate and how that played in just to the general analogy we're doing with this conversation. I guess our conversation is, the way I understand it is, we're just basically saying, if a developer owns an entire city, you can go find another city to live in. You don't have to buy from that developer. You don't have to live in that city. We just want to give consumers a wider range of opportunities to download, and we want developers to have a wider range of platforms to supply to. We're not trying to tell Apple or Google or any other digital platform how they operate. We just want to make sure that we have more opportunities to enter the market for consumers and developers. Is that correct?
Absolutely. Right now, if you want to reach mobile users of any kind in the US, you have to go through Apple and Google. There is no other cities to move to. This would give you competition in terms of how you distribute to users, so that the ability to reach users isn't regulated by two dominant companies who can cut off your access on a whim.
Thank you.
Hang on just a second. Representative Evans, coming to you next, and then Representative Oliver, and I'll come back around.
Thank you, Mr. Chairman. I had a question about subsection D, starting on line 59, where it says, any agreement that violates any provision of this code section shall be void and unenforceable. And I was concerned, if we're trying to let the market work things out, and we want to let people have freedom to make contracts with different platforms and things like that, why would we not allow perhaps some of the larger platforms or even some of the smaller platforms to have exclusive deals with some of these app folks? It seems inconsistent with the stated purpose of the bill.
So I'll respond in two ways. First, I'll point out that the agreements that are being referred to here are really not bilateral agreements in the way we normally think of a negotiation between two parties. But the dominant platforms post terms and conditions on their websites. They don't negotiate them with the vast majority of developers. They say, take it or leave it. We have market power, so we know you have to adhere. Otherwise, we're going to kick you off our platform. But the second thing I would say is that this does not change the ability for Apple and Google to have their own app stores, or to offer deals to developers to advertise in the app store or anything like that. You'll still be able to have an app store on your iPhone or a Google Play Store on your Android phone. You'll just have a choice if you want to have another app store as well. What they do within their app store is not the primary focus of this bill. It's about having competition across app stores.
Thank you. And then on line 61 to 62, can you tell me that this is subsection E that says this code section will not apply to special purpose digital application distribution platforms? What are those?
So those are we're thinking about things like gaming consoles, or maybe a special purpose music player like the iPod used to be. I don't know if there are still iPods around anymore. But that's saying if you have a video game system, the rules here wouldn't apply. And the reason is that the dynamics in that market are very different. I think as Representative Carpenter pointed out, the way that video game consoles make money is not by charging for hardware in the way that Apple and Google do. It has to do with the apps and the games on the consoles. Also, competition between the consoles, a lot of that has to do with what games are available on the different consoles. That's not as much the case with mobile phones because you can get the same apps on the different platforms. And then the market power that these other special purpose hardware providers have vis-a-vis developers is nowhere near the power that the dominant platforms have. They don't have the ability to just completely impose anti-competitive terms that undermine the incentive to develop and innovate.
Okay, and I just have one final question on lines 36 through 38. This is subsection B4, where one of the things we are going to prohibit is imposing restrictions, conditions. What are we trying to prevent with this section?
That's a great question. This actually highlights another instance of what I would call nefarious anti-competitive conduct by the platforms. Given in your iPhone app, you have to use the Apple Pay. One way developers thought they could get around that is offering users the ability to sign up for goods and services online. So if you go to the browser, then you can sign up and pay a lower rate for your Spotify account or something like that, and then be able to access those services through the app. It was very hard to let users know that option was even available. So they would developers would put language in the app saying you can get cheaper prices, or you have the ability to sign up and subscribe through your browser or on your computer. So what Apple did was prohibit those kinds of communications in the app. They started rejecting app updates that had that kind of communication, and said, even if you make cheaper prices available elsewhere, we're not going to let you tell your users about it. That was before they took the next step of just not allowing you to do that.
Thank you.
All right, Representative Oliver.
I understand, sir, that you are a national coalition. Where are you speaking from this morning?
I am in New York right now. I'm usually based out of Kansas City, but I'm in New York right now.
And your firm, is it a firm or are you in-house with this coalition?
I'm with a firm called the Gunter Law Group. We're based out of Washington, D.C., but we have we're a relatively small firm. We have attorneys in Washington, Kansas, and Illinois.
How many states is your particular coalition seeking to have legislation introduced that's similar to 229?
Well, I'd say we're seeking to have it. We would ideally have it introduced in 50 states. We think this legislation should apply everywhere, but as of right now, I know of at least a few states that have bills that have been submitted. I'm not sure the exact number though.
And there is none that has passed anything like this?
Not yet. Many of them are at the same stage, the early stage we are now.
Do you feel comfortable that in all the states where you're seeking legislation that a term like special purpose digital application distribution platform does not need a statutory definition?
I believe so. I think that we've looked at it, and we think the definition provided in the draft legislation, both here and the other states, should be enough to protect those special purpose platforms from any impediments.
Thank you.
Okay. Representative Carpenter.
Yes.
Oh, I'm sorry. Hang on.
Thank
Yeah.
you, Chairman. I was going back to the real estate piece because like Whip Kelly, I love some real estate, and knowing the restaurant business and location, it kind of rings a bell. And so to your scenario, and like he said, Apple controls that whole city, but not only that, but they charge you the same whether you're on the corner of a red light as you do if you're in the middle of a street. And also, they actually put their apps in the best locations and make all the other apps fight for the rest of it. So that's another scenario.
All right, any other questions for Mr. Kessler? Oh. All right, Mr. Leverett.
Good morning. My name is Rob Leverett. I just want to make sure I'm sort of understanding the effect of the legislation. So I gather customarily when a developer of an app gets the app on one of these platforms, there's not a traditional written contract signed on the terms and conditions of placing the app on the platform. It's more like a licensing agreement or a user agreement that's automatically deemed to be agreed to by the fact that they've been allowed to put their app up on that platform.
Yes, when you submit your app, I believe that in doing so, you're agreeing to the terms and conditions.
And I think thank you. And I think you touched on this earlier that obviously I don't know to what extent we can impact or impair an existing contract. So is it your belief that the restrictions set forth in the bill would just apply prospectively to anyone who would come onto the platform subsequently, or when that licensing agreement would expire and have to be renewed if such a thing happens?
I think it would apply to all apps on the platform. One thing I'll point out is that both of the platforms are constantly changing the terms of the developer guidelines, what they call them, the terms and conditions for accessing the store, usually making them more restrictive unless they're coming under some kind of antitrust scrutiny. And when they make those changes, it applies to everybody on the platform at that time, whether or not they submitted their app before the platform or before the change or after. This would have the same effect.
But if I'm already on an iPhone or Android, and some of these restrictions are in the user agreement, if this bill were to get approved and become law, it couldn't affect any of those existing user agreement terms, could it? It would just be prospective, would it not?
Well, no, it could. Apple would no longer be able to, prohibit you from offering, a link for PayPal or a button for Square in your app. And that's whether you're in the App Store or not at the time this bill is passed.
So it would render void existing contractual provisions in those user agreements that were in effect at the time.
Yes, they wouldn't be able to enforce those provisions. And I should be careful, about whether or not these are really even contractual provisions. It's difficult to talk about contractual provisions here because there's not any level of enforcement. The enforcement is just the developers, or rather the platforms, kick you out of their store if you don't adhere to their guidelines. So they unilaterally impose guidelines and then kick you out of your store if you don't adhere. It's not like they go to court and sue you for having breached or anything like that. So whether we would call those guidelines a bilateral contract, I don't know, because there's arguments about what their binding effect on the platforms, especially since they can be unilaterally changed by the platforms and are.
Okay, so I'm gathering then the intent here would be to render unenforceable any of the existing provisions of those agreements, even though they're being applied to people who are currently on the platforms already.
Right. Yes, it would be rendering those rules and their guidelines unenforceable.
Okay. All right. Thank you.
All right, any other questions? Nothing online either.
No, we're good.
All right, thank you, Mr. Kesson.
Thank you.
Who's next?
Representative Carpenter, do you have something? Yep, I got one more speaker.
Yes, sir.
It's Miss Kirsten with TAO. She's the general counsel with TAO. Thank you for your help today, Brandon.
All right, Ms. Kirsten, floor is yours.
Good morning. Thank you very much to the subcommittee for convening this hearing. I'd also like to thank and commend the members of the subcommittee and your staff for the commitment that you've shown to promoting competition in the digital marketplace. My name is Kirsten DeRue, and I'm the Chief Privacy Officer and General Counsel of Tile Inc. While Tile is not domiciled in Georgia, our experience with Apple and its anti-competitive practices is unfortunately not unique. The abuses that have unfolded over the years have affected virtually all developers and consumers of mobile app stores. Yet, few feel comfortable speaking up about their experiences for fear of retaliation or retribution by Apple. Indeed, speaking up is difficult for us too. Apple in many ways controls the fate of its app ecosystem. However, I'm not here to ask for protection or even relief. I'm here because right now, we have a unique opportunity to begin to restore innovation, competition, consumer choice, and freedom to the app ecosystem. I'm here to share our story in favor of a level playing field and in favor of HB 229, which will help drive competition and help Georgia consumers get the benefit of great services and new innovations at fair prices. Really quickly about Tile. We help people find their lost items. We are a tech company. Our devices work with our Tile mobile app to provide an interface to help people find their keys, their wallets, their purse, really anything. We help address a global pain point. People spend about 365 days of their lives just looking for lost items. We also embed our software into third-party products like headphones and laptops. We are a small company. We only have about 125 employees, but we have a successful digital subscription business, over 180 patent assets, and much of our success relates to our collaboration with a diverse group of tech partners that includes Hewlett-Packard, Google, Intel, Amazon, and importantly, Apple, who was a critical platform partner since 2013. However, our partnership with Apple has taken a very sharp turn in the wrong direction. We talked a lot about Apple's developer terms, and I think it's helpful to start with a little context there. The developer terms, which are contained in a litany of different documents, including guidelines, user agreements, license terms, are basically the rules that we have to follow to offer our app in the App Store and on your iPhone. From time to time, our engineers get a pop-up message from Apple alerting to them that there are new terms in our App Connect portal. When new terms appear, we're blocked from updating our app until we agree to them. The new terms are offered on a take it or leave it basis without meaningful notice and without an opportunity to negotiate. Those terms, as we've talked about today, currently require apps to be distributed only via Apple's App Store. No competing app store is allowed. Essentially, the only way to make an app available to an iPhone user is to agree to these terms and offer our app through the App Store. Apple also imposes a requirement that most, but not all, digital purchases be made via its in-app payment system. Again, for those payments that are subject to it, no competing payment systems for applicable digital purchases are allowed. And for the privilege of using Apple's in-app payment system, we have to pay Apple as much as 30% of our digital revenues. Congressional findings have indicated that there is no nexus between the 30% fee and the cost of Apple running the App Store. Apple App Store revenues are in the billions, but the former director of revenue for the App Store estimated that Apple's costs for running the App Store are less than $100 million. Yet, because of Apple's prohibition on competition, owners of iOS devices have no alternative means to download their apps other than the App Store. Developers are forced to relinquish 30% of their revenue in exchange for what's really a payment processing service. Imagine a small coffee shop in Georgia being forced to hand over 30 cents to a processor in order to sell a $1 cup of coffee. That's reality for a lot of us in Apple's App Store. More importantly, though, Apple's artificial and unilateral prohibition on competition leaves no alternatives for consumers. Without regulatory intervention, Apple will be free to increase its fees over time, further crushing developers and consumer pocketbooks. But unfortunately, this is just the beginning. For many developers like us, Apple isn't just the owner of the App Store. Apple is also a direct competitor, which makes the App Store fee dynamic that much more critical to address. After years of being a critical platform partner and even featuring us on stage at Apple's Worldwide Developer Conference, working together closely to develop one of the first Siri tech integrations, reports started surfacing that Apple was going to release a Tile-like competing hardware product. Shortly afterwards, they decided to no longer carry our products in their retail stores. To be clear, we welcome competition, but it has to be fair competition. And after about the past year or so, Apple has exploited its market power to advance its own interests at our expense in numerous ways. Here are just a few examples. They copied our app. A new Find My app was introduced with iOS 13 in late 2019 that included Tile features. Find My is installed by default on all Apple phones and cannot be deleted. At the exact same time as that update, Apple made changes to their operating system that denigrated our user experience while leaving theirs streamlined and otherwise intact. Apple also started sending prompts encouraging our customers to essentially turn Tile off, but they serve no prompts to turn off Find My. Apple hired an engineer we sent to work with them on that Siri integration that I mentioned. Apple refuses to give us access to certain technology that we could use to enhance our user experience. Instead, they're reserving that technology only for customers of their anticipated competing Tile product. Apple launched a Find My Network program where they withhold critical data unless we abandon our app, our competing app, and join theirs instead. They could easily grant us access if they were interested in fair competition. Taken together, these examples show that Apple acts as a gatekeeper of third-party access to data and technology in ways that favor its own interests. Apple, as we know, owns and controls the entire commercial iOS ecosystem. They own the hardware, the operating system, the retail stores, and of course, importantly, the App Store marketplace. This gives Apple access to competitively sensitive information, including the identity of our customers, subscription take rates, retail margins, and more. And their control over the ecosystem generally enables it to identify any successful app category and basically take it over by manipulating the ecosystem to give itself a sharp competitive edge. Apple has done this in one way, shape, or form to categories like screen time apps, flashlights, email apps, remote payments. It's happening right now to health apps, fitness apps, news apps, and more. All the while, these small competing app developers line Apple's pockets with as much as 30% of our digital revenue to help fuel more anti-competitive behavior. If left unchecked, Apple will become a $3, $4, $5 trillion company. Innovation will continue to suffer. Consumers will ultimately be left with even less choice, lower quality, and of course, higher prices. While testifying on similar behavior in front of Congress last year, I used an analogy that might be helpful here. This is like playing a very warped game of football. You might have the best team in the league, but you're playing against a team that owns the field, the ball, the crowd, and the league, and that can change the rules of the game in its own favor and at any time. That's the field everyone in America is playing against Apple on. And importantly, with this bill, we're not saying that Apple should not be profitable, Apple should not be successful. We're only saying that should Apple decide and choose to compete with apps and services on its platform, it should just do that pursuant to equal rules applicable to all players. As Mr. Cresson mentioned, in a common refrain in response to concerns about Apple's anti-competitive conduct, they often claim that prohibiting or impeding competition on its platform is necessary to ensure privacy and security of its users. As Mr. Cresson mentioned, this is simply not true for many reasons. But here's one pretty obvious one. Nowhere does Apple say, if an app store or a payment method can meet certain reasonable or objective standards for privacy and security, then they may compete with us. Instead, the rule is no app store or payment method may compete with us. The blanket prohibition on competition has no reasonable nexus to privacy or security. And as Mr. Cresson mentioned, there are many third-party sellers and payment methods with excellent privacy and security practices, and that operate currently on Apple's own platforms, including the iPhone and Mac. The bottom line is that this is what happens when you have a monopolist private company acting as a de facto regulator. The regulations will always tip the scale in favor of the monopolist, and consumers lose the benefit of choice and fair prices. The functioning of a robust, healthy app distribution ecosystem is dependent upon open platforms that do not favor the owner. HB 229 is a critical step towards restoring innovation, competition, and consumer choice in Georgia, and will serve as an example of what good looks like to regulators around the world struggling with how to free their citizens from the reign of big tech. Tile commends the subcommittee for its leadership on this critical issue and is looking forward to the bright future of Georgia customers who will be so well served by this bill. I'd like to thank you again for your time and look forward to answering any questions that you might have.
All right, questions for us, Ms. Daru, Representative Reeves.
Thank you, Mr. Chairman. I followed a lot of what you said, and I want to kind of return a lot of what you said to the actual proposed legislation that we're looking at. And you spoke a lot about the anti-competitive behavior and the, I guess, copycatting apps and positioning those where they're, more favorable than the market originators or innovators. And, and so and all of those issues, I don't know what is the subject of the litigation that's ongoing, but my guess is that probably a lot of those issues are being dealt with in the litigation. Is that right?
I can't speak to litigation. We are not part of any litigation. But not to my knowledge.
So,
yeah.
And again, I'm working with limited information here. Today's been very educational, but through your testimony earlier, there apparently is pending litigation at the federal level on some of this matter. But what does this legislation do specifically to address the issues that you raised about the anti-competitive behavior, specifically with copying apps and then re-releasing them in their own version? Does this legislation specifically address those type things? And in your mind, what does this litigation, or I'm sorry, not litigation, what does this legislation most address as far as the issues as you see them?
That's a great question. So I see this legislation as a critical first step towards leveling the playing field that so desperately needs to be leveled. Number one, it very importantly enables competition at the App Store and payment level. That will give consumers choice and will enable fairness in the app ecosystem, enable developers in Georgia to take money that would otherwise be to go to Georgia, put it back in the consumer pocket, and or pour it into their own businesses to fuel innovation and competition in Georgia. It also, it's not comprehensive, but it also does a fair number of other things, like prevent the use of competitively sensitive data, from companies, small developers in Georgia, from being used by Apple for purposes other than operating their app store, prevent some of the self-preferencing behavior. Is it entirely comprehensive? No, but it is exactly, it's a critical step, and it's the right step in the right direction.
And I'm going to put you on the spot, and I don't know if you, if you have a way to answer this question or not, but I'm trying to look at this thing all the way around the circle. I understand what you are saying. You've got platforms that introduce you, that open a window, that introduce you to an audience of literally billions of people that can access the product. And if within that there are some things that are unfair, then that's a lot of what we're talking about right now. But this platform introduces a product to an audience of people that's larger than any other way that you would be able to introduce people to your product. So what I'm hearing is that the 30% is too much. I think that we heard earlier testimony that if the revenue is less than $1 million, then it might be something like 15% for digital apps. But are you prepared to say what is a fair amount? I mean, are you able to answer that question? Is it a sliding scale? I mean, what do you consider to be a fair percentage for access to that window that opens this product to literally billions of people?
So it's not my place to say exactly what the price should be. The price should be whatever the market brings to bear. The problem right now is that there is no market and no competition because of artificial prohibitions on competition imposed by Apple. What this bill does is that it opens the door to actual competition and a market so that those prices and those fees can develop and evolve fairly and give consumers those choices. That's what we need to ensure fair and reasonable prices moving forward on the App Store.
I don't have any other questions.
All right, Representative Carpenter.
Yeah, I got this little quote that you might like to hear. I think we're realizing that 30% is way too much, says Philip Shoemaker, a former senior App Store executive who left Apple in 2016. Credit card companies charging roughly 3% to process payments. It should be closer to that, he said. So I think there's a pretty well common knowledge that competition is going to drive the prices down, but this is clearly a huge revenue center that is stifling innovation and costing Georgians millions of dollars. And furthermore, Mr. Representative Reeves, lines 39 through 44 discuss kind of the provisions in the bill that would protect what she's talking about, where they're using the information derived from their software against them.
All right. Ms. DeRue, you were talking about this is a good first step. What else do you see coming down the road that we should be doing?
Down the road, making sure that that all developers are treated fairly, that Apple is prohibited from picking winners and losers and king making, and the like. Again, this is an amazing first step that gets us largely, or at least the consumers and developers in Georgia, a huge leg up and a leg up above and beyond all other developers and consumers in any other state. I see this as a really phenomenal opportunity for business and consumers in Georgia in front of us right now.
All right, thank you. No more. All right, I believe those are the questions we have. Thank you, Mr. Rue. And now we're going to switch to Morgan Reed. Mr. Reed. I think, yeah, okay, good.
There we go. Am I live?
You're live. Go ahead.
Thank you. Good morning, members of the subcommittee. My name is Morgan Reed, and I'm the president of ACT, the App Association, and a software developer. The App Association is the leading trade group representing more than 5,000 small software and connected device companies in the app economy. Our industry is part of a $1.7 trillion ecosystem led by US companies and employs about 170,000 people in Georgia alone. Our members companies, including several here in Georgia, like Turbojet and Southern DNA, create the software that brings your smart devices to life. Their innovations propel the data-driven evolution of these sectors and compete with each other and larger companies in a variety of ways, including on privacy and security protections. The author of the bill has highlighted some billionaire companies like Fortnite and EU-based Spotify that has more than 100 million users. These companies simply don't want to pay for what the platforms provide. I have to worry about the hundreds of thousands of truly small developers like Southern DNA that actually need the services. You talked about the real estate question. We don't have Spotify's name ID. So the idea of cutting the cost for billionaires won't help my members at all. We have serious concerns with the proposal you are considering for basically 3 reasons. Number 1, we see that it undermines the value of the services that we purchase from platforms that allow truly small companies to compete. We all have the same real estate on the App Store. If we've got the lineup going, if you search for a term, it pops up all of the apps, whether you're a big company or a small company. It also increases the cost of us doing business by making us spend money on search engine optimization and other marketing. Number 2, it jeopardizes the privacy, security, and safety of consumers. And number 3, it weakens intellectual property protections for app makers and content creators. Basically, it all boils down to 3 things that my members need. You said it earlier. They need access to a global market. They need the ability to offload overhead, whether it's credit card processing, but it's also preventing piracy, dealing with patches, dealing with update cycles. And most importantly, we need to ensure customer trust. Customer trust is fundamental for competitors in the app economy, especially for smaller firms that may not have substantial name recognition. Platforms have been the leg up we need, and they continue to compete with each other. I don't think anybody thinks that Google and Apple are friends if you've read your newspapers. And they compete with each other on privacy and security to the benefit of my members and ultimately the consumer. I need to take you all on a short trip down memory lane to discuss what the world was like before we had platforms creating a trusted space. Generating consumer trust in software was incredibly expensive. Developers spent up to 70% of their revenue on distribution, paying for magazine ads, marketing costs to publishers, and literally buying shelf space at big retailers. This is very costly compared to the fees of about 15% most of my members are going to pay, or the 30% we've heard talked about. It was also a slow process. Getting software onto the shelves at Best Buy could take a year or more if you weren't a big name like Epic's Fortnite. And don't forget, you had to agree to buy back any software you didn't sell on that store shelf. In the current environment, I'm looking at a couple of weeks from the time that I finish coding until customers are using and trusting my software. Because of this trust, there are more than 2 million apps available and in use by billions of people around the world. Number 2, HB 229 would weaken the cybersecurity, privacy, and safety of app companies and consumers. Consumers now depend on mobile devices to store their most important information, and the ability to process that and protect that data is vital. Today's software ecosystem depends on strong privacy and security protections at the platform level. In particular, app stores ban apps that promote pornography, assisting stealing music and movies, and significantly, apps that encourage illicit stalking or tracking of a person. Stalker apps operate outside the bounds of what is allowable in the current app stores and mobile operating systems by accessing troves of personal data, including location, messaging, and calls. Stalker apps put domestic abuse victims at further risk for harassment and harm by abusers. In 2019, the Federal Trade Commission acknowledged the dangers of allowing third-party apps to bypass manufacturer restrictions in its first ever action against stalker apps. The FTC stated in its enforcement action that, quote, the purchasers were required to bypass mobile device manufacturer restrictions, which exposed the device to security vulnerabilities and likely invalidated manufacturer warranties. That leads me to my third point. HB 229 would likely help content piracy. This proposal would allow IP infringers to circumvent the measures platform uses to sniff out IP theft. This matters to Georgia more than most. Georgia has become a hotspot for incredible movies, TV shows, and music. My wife is addicted to The Walking Dead, so I've seen a lot of Georgia. Currently, there are 38 films under production throughout Georgia, including big hitters like Spider-Man 3. Under HB 229, platforms would be required to allow the installation of entire stores that include apps around piracy, pornography, and stalking apps, essentially bringing the dark web into every corporate network and household that has a teenager. Because IP infringing software are notorious purveyors of malware, the sites that support them are offering conduits for identity theft, botnets, and extortion. Lastly, I want to note that the major app stores are not the only way to reach a broad audience. The reality is our members develop their apps to reach the most customers possible as quickly as possible. Therefore, we usually deploy apps that reach through the stores as well as through the web. For example, I don't have Facebook on my phone, but when I want to check in, I just open my phone's browser and go there. Same for eBay, my book reader, and several other products. The top line is this. My members need 3 things of value from the platforms: access to a global market, offloading overhead, and most importantly, trust. HB 229 undermines all 3 of those without giving us new customers or unshackling our innovation. With that, I look forward to your questions, and I'm happy to talk a little bit more about software development and how we do it.
All right, questions, Representative Reeves?
Thank you, Mr. Chairman. Real quick, there was a testimony earlier by an individual who was representative of a coalition for app fairness, and he said that represented about 40-something developers, and that it could be multiple apps within those different developers. But regardless, it seems like I don't know how many apps are out there, but it seems like there's probably a lot, hundreds of thousands, I don't know, a million apps. I wouldn't know, but so obviously his position with the developers and apps that he represents is clear, but as far as the industry as a whole, is there a sense, or do you have any way to articulate data that suggests that the app industry and developers as a whole favor one way or the other? And then within that, what I'm really concerned about is Georgia apps. And I don't know how we have that information broken down, but this would seem to impact Georgia apps. It's my understanding that this is since it's a state issue. And so where are Georgia apps on this, and where is the app industry as a whole?
So there's a couple of, and great question. And I think I've provided the committee some letters from some Georgia developers, as I discussed, Southern DNA and some others that are down there building apps in Georgia for Georgia businesses. Their concern with HB 229 is primarily that it is a blunt instrument. And what it ends up doing is breaking the real trust relationship that we need the platform to provide. Think about yourselves. When you go to the App Store and Apple App Store, you don't start asking questions about, well, is this going to install malware on my phone? Am I going to have to think about that? We heard earlier about, I think you said, well, it's specious because the PC and the phone are the same. I don't think that's true in anybody's life. My phone knows more about me than my PC does. I don't install software without thinking about it on my PC. On my phone, if I'm in the App Store and I need to say, scan a document, I go into my app store on my phone, I say, document scanner. I see 4 or 5, I look for the ones that have the highest rating, and I download it. I didn't do a background check on that company. I didn't look for how big the brand name was for the company, because I'm essentially depending on a lot more than payment processing. I'm dependent on that company, the platform, to have basically said, it's not going to steal my data. It's not going to install malware. It's not going to illicitly track me. That's the trust relationship that customers get. So in your question about how do Georgia developers feel, I want to be clear. It's not as though the developer community doesn't have plenty of things to complain about the platforms, but mostly it's about how do we get the platforms to give us more services, more capability, make it easier for us to reach a bigger audience. We know what it's like to go it alone and try to promote yourself on the web and just be, what's that old line? On the web, nobody knows if you're a dog. Well, we want to figure out how do we access customers in the quickest, easiest way possible. And so from our perspective, we need more from the platforms to do a better job. We need better real estate. We need more trust, because right now, That's the growth in our market. It's not peeling away. It's figuring out how do we get more from it.
But as far as the industry as a whole, I don't feel like and if you don't have an answer on it, that's fine. If it doesn't exist, but do we have any way of saying that the app industry as a whole leans one way or the other?
The app industry as a whole leans towards more privacy, more security, more protection of consumer information. How you achieve that is something that we argue about throughout the industry. I would note they've got about 50 members. I'm sitting on more than 5,000 companies that are part of our organization, as I said, including several in Georgia. I know what my members are saying, and their complaints about the platforms are not designed around breaking that trust. They're about getting more for their money. So from my perspective, the industry is coalescing around the idea of lots of competition, but that does a better job of protecting privacy, security, and frankly, giving us access to a bigger market.
Let me ask you this: does the coalition that you represent give you some muscle, I should say, in negotiating?
So yeah, and obviously I can't breach any NDAs, but yes, we have actively participated with both platforms. Good story. Actually, it was a company out of Georgia. I hope that doesn't, Alabama. I hope that doesn't create tension with anyone there in Georgia. One of our Alabama members had an application that had a knockoff out of Germany. It was close to being legal, but they stole some of the artwork. They stole some of the formation and everything. That company was having a hard time getting Apple to listen to them. So we picked up the phone, we talked to representatives, we got a hold of developer relations, and pretty quickly we got to a resolution. The German app was removed, the product moved forward. So yeah, we do negotiate, but we do it all under NDAs. We do it in a way that protects the industry, and we do it in a way that makes sure the small guy has some even playing field with the Epics and the Fortnites of the world.
Good. Representative Carpenter.
Thank you, Chairman. So a couple of things as I was listening, you spoke about intellectual property, and I think we had a speaker on right before you that was talking about how actually her app was, what they were doing. They were actually, Apple themselves were actually stealing what she was doing and taking her business model away. And so my that's just a statement. But my question is, the Southern DNA you talked about, do they sell digital goods, or is it?
So here's the part that's interesting. We've been talking about this 30%, and the reality of the world is 87% of the apps out there don't charge anyone anything. So nobody's paying 30%. It's clicks and mortar business. Companies like Southern DNA, Motion Mobs, Turbojet, you're going to walk in and say, hey, I need my point of sale system to go mobile, right? You've been using a PC in the back room and a terminal up front, but I want all my employees to have access to it mobile. My companies go in and build the immense amount of software that's tying grown-up legitimate business together. That's growing Georgia's ability to compete in the auto industry and everywhere else. And that requires that businesses completely and utterly trust that their corporate secrets aren't going to get stolen. So for our companies, that's why you keep hearing me coming back to that part of 229 that raises our biggest concern. You raised the point about Tile. I'm pretty sure that Tile is in a lawsuit with Apple, and I think there are remedies. And if Tile can prove that Apple stole their intellectual property, well, we have an entire court system dedicated to that. So I don't want to knock anyone's ability to use and make a claim about a patent being violated or copyright being violated. So if Tile has a complaint and it works, that's, we should talk. But within the compound of where we are right now, what I'm concerned about at this bill is what it does to breaking down the trust that we need in order to get our products in the hands of businesses and people in the state of Georgia.
So are you contending that opening it up to a third-party payment processor that happens all over the web on a daily basis would somehow fracture this ecosystem and make it less viable or less safe? Because
So-
there's, you've made
Right, we-
comments about pornography and whatnot, but I can pull up Pornhub app on my phone right now and download it. So, I mean, it exists.
Not the
It
app. No,
exists.
that's it. You can't pull down the Pornhub app. You're actually doing a great job of making the case. You can look, oh, you're on Android. Sorry, I thought we were talking about iPhone. You can't pull down the Pornhub app on Apple because they don't let it on the store. Now, back to your earlier point though. Remember, the bill does something more than just talks about payment processing and sets rates. It actually says that the platforms can't stop other stores from being established on their devices. And so then the question is, who controls what goes on in that store? Who controls what the privacy and security realms are of that store? Also, the question becomes if that store has access to all of the hardware capabilities that are on that device, including tracking, including data stores, all of that information. So right now, the bill as it's constructed, part one really establishes the ability to create and enforce other stores installed onto the device. So my concern is essentially dark web stores that are Apple is required to let be installed on their devices create a real problem, especially if they have access to all of the sensors and all of the information that consumers may be legitimately storing on their phone.
But can Apple not set the parameters of the protections that they require in their app store before they allow that platform to be downloaded on the phone?
Well, the bill's fairly simple at present, and it doesn't appear that it actually does much to actually say that. In fact, it specifically says that they are not allowed to use punitive actions through terms of service to prevent a whole panoply of characteristics. I think that you would find that the way that 229 is currently described, I think there'd be a legitimate case in court that if Apple tried to say, hey, look, this store looks like it's mostly for bad things. We don't want you having access to our device. I'm not sure that wins. And I'll point out why. We've already had some cases in courts that deal with this exact question. What are you allowed to make sure that people have access to? You can't bar the web from, as we know, you can't bar stuff on the web. You just said it yourself. You can find whatever you need there. So there are restrictions. If Apple says you can't have access to geolocation data, and the platform is primarily for theft, but it has a couple of legitimate apps on it, then that store is going to claim we've got legitimate applications, and therefore, therefore we can't be banned by Apple. So the question is, how many? Is it a preponderance of the apps on the store? Is it one bad app and 100 good ones? I think a lot of that would have to be fleshed out in the legislation.
Yeah, I think we're addressing that in lines 46 through 49. It says exclude any developer from the digital distribution platform or otherwise disadvantage any developer for any other reason other than failing to meet fair, objective, non-discriminatory standards for privacy, security, quality, content, and digital safety. So I understand your concern in that matter, and I think this bill addresses that
Yeah.
point.
I think the devil would be in the details on that one, because Google's going to claim, or Apple's going to claim, that they're doing an element for privacy and security. We already talked about that. One of Tile's issues is, do they have the same amount of access to the hardware that Apple does? Apple says, hey, we're concerned about notifying users about how that data is being collected. I think that it's fair, reasonable, and non-discriminatory. FRAND is a term that lawyers spend a lot of time and a lot of money fighting about. And right now, I don't think that this bill brings my community much more to the table. There's one other part that I'd mention. One of my members talked about this earlier. They said, so we have a whole bunch of apps, app stores on the platform. Do we get access to any new customers? No. Are there specific capabilities outside of the edge cases like Tile that we can't do? What's the technology that we are incapable of really promoting that our consumers are demanding, or that we see real opportunity for? So far, none of my members have said, if only Apple got out of the way, we'd be able to shoot to the moon. I think right now, our industry is already in a rocket ship mode. Globally, we have 500,000 unfilled jobs. I'm sorry, in America, we have 500,000 unfilled jobs. I heard you talking about unshackling innovation. My companies don't have a lot of problem raising money from venture capitalists or finding money to support what they're doing. In fact, anybody that knows an app developer knows that we spend back before COVID, we spend every time at a party with somebody coming up to us and saying, I got a great idea for an app. I don't have any money, but I got this great idea for an app. We're like the doctor when people come up and say, I got a pain in my back. Everybody's got an idea for an app. So right now, we don't have a shortage of ideas. We have a shortage of making sure customers see the platform as trustworthy, as valuable as an asset that allows us to build our apps on top of it. So I think your question is good. If H229 can move in ways that can help modify some of those things, I'd be happy to discuss it more with you. But I've got, blinders on, and when it comes to how do we help app developers, especially in the state of Georgia, succeed. And that means access to customers, access to trust, and getting rid of that overhead so that you can get there quicker, faster, and update more often.
All right. Any other questions? All right, thank you, Mr. Reed.
Thank you.
And next, we're going to go to David Edmondson. Mr. Edmondson.
Good morning, Mr. Chair and members. My name is David Edmondson. I am TechNet's Vice President for State Policy and Government Relations. TechNet is the national bipartisan network of technology CEOs and senior executives that promotes the growth of the innovation economy by advocating a targeted policy agenda at the federal and 50 state levels. I am here testifying in opposition to HB 229. My organization did submit a letter detailing our concerns on Friday. In short, HB 229 would undermine the entire app delivery and development ecosystem while placing consumer data and privacy at considerable risk. App stores are global digital marketplaces that promote innovation, drive economic opportunity for small companies in Georgia and across the globe. Building, maintaining, and supporting app stores and app development tools are key elements of this success. Leading app stores invest vast resources in an infrastructure to support regular malware scanning, prevent restricted content like hate speech, and manage safe and secure payment activities, as well as creating the internet infrastructure to deliver the apps, as well as provide support and training for developers. This bill undercuts those ongoing investments and places the state in the position of intervening in the marketplace to advantage one group of companies to the detriment of others. For example, the bill's restriction on the use of exclusive modes of distribution would essentially mandate sideloading, which is the practice of downloading unvetted applications to a connected device. And while not all platforms require exclusivity in distribution, removing it for those that do would undermine the platform's ability to provide a secure environment for its developers and user communities. So all applications on leading app stores for example, are carefully vetted to eliminate security risks, which successfully prevents the vast majority of malicious apps from entering the environment and reaching Georgia users. By contrast, sideloading allows access to apps that are unavailable in official app stores for any number of reasons, including those that risk a user's privacy and security. And once these malicious apps are installed, they expose users and their broader connected networks, everybody on their phone, to very real cybersecurity threats. Malware introduced through sideloading could potentially allow hackers unauthorized access to a consumer's sensitive data, photos, and even the device's camera or microphone. The technology industry is fully committed to securing privacy and security for consumers and engages in a wide range of practices to provide consumers with control over their data. The success of these efforts hinges on the ability to build and maintain trust from their consumers, and choosing partners and platforms that ensure a secure environment is of paramount importance. Unfortunately, HB 229 would completely undermine this and open up Georgians to new privacy and cybersecurity risks, and therefore we must respectfully oppose the bill.
Representative Carpenter.
Is it fair to say that the individuals that are selling on the digital platform, selling digitally, are subsidizing all this security and safety that you and the former speaker were discussing?
Are they subsidizing it?
Yeah, so it seems to me like the people that are actually selling, doing digital transactions are the ones subsidizing all the safety and protocol that everybody's so concerned about losing.
Sure. So I think if we want to go back to an analogy that's been used repeatedly, and we talk about real estate. So if this were a shopping center, that those fees go towards providing security, go towards providing the landscaping, go towards providing maintenance, go towards ensuring that it is a safe environment where people feel comfortable shopping, knowing that that place is going to be a place that that they can bring their families and not have to be concerned about what's going to happen while they're there.
So in reality, Georgia consumers are paying the brunt of the ability for everybody, even if they don't download the app at all, they're protecting all the other apps that maybe they never use. They're actually the ones they're paying for are paying for that safety. Is that a fair assessment?
If no, if you're not downloading an app, you're not paying for anything. And I think as Mr. Reed noted earlier, I think the vast majority of the apps in the App Store are free right now.
Right.
I
Yeah.
don't know how that would impact Georgia consumers.
Well, because the consumers, when they're buying things online and paying and Apple's collecting and Google's collecting 30% of that dollar, they're supposedly using that 30 cents to spreading it across all the other apps to protect the consumer, whether they download the other apps or not. Does that make sense? So if all the revenue to protect all the apps you're representing is raised on the backs of Georgia consumers that may not download those apps at all, I think, I don't, that sounds a little strange to me.
Well, it's not about the individual apps. Those individual apps are going to be developed by those individual developers. But again, before they get placed in the App Store, they're making sure that they do not support illegal content or free of malware and other issues that are going to raise security and privacy concerns. So I think they're paying for the infrastructure that is in place, which is a vast and ongoing investment. So it's less about the individual apps and subsidizing what those apps do. It's about the broader infrastructure that is required in order to access billions of users overnight from building an app in your bedroom.
All right, Mr. Edmondson, what about the restrictions that Apple puts on these app developers to use their payment system and other products of Apple? I think what I'm hearing here is a lot of that is causing problems for the developers when they can do a cheaper system, but they're forced into one that's more expensive by Apple.
Right, and I think again that goes to an issue that Mr. Reed spoke to quite well. When you open this up, you're not just opening it up to people who are well-intentioned. As he talked about, and I'm sure that the author would point toward lines 46 through 49 in the committee sub. But you're effectively leaving that open to the courts to figure out what constitutes a reasonable reason for, a fair, objective, and non-discriminatory standards for preventing a new app store from being required to be placed in access on these devices. And in the meantime, as those get litigated and as you figure out whether, like Mr. Reed said, it's a preponderance of the apps that are available and whether or not those are safe and secure, or whether it's, requires all of them to be, or whether you just have to have one or two legitimate apps, you're going to be placing Georgia consumers at very real risk because they are rightly so in a position where you trust what's available because of this massive investment that has been put in place by the folks running these platforms to ensure that the apps that are on there are safe and secure. And while new third-party unvetted apps are placed on there as a result of this bill, forced to be placed on the app, on the device, you're going to have countless users just downloading apps because they're used to knowing that when they go to this virtual store, that the wares that are being sold to them are safe. And what's going to happen in the meantime is you're going to place these individuals at considerable risk. And it's not just small things like they're going to collect your location data when it doesn't tell you that you're doing so. There are people who want to be able to put Georgians in very compromising situations to then try and pull money out of them because they've had access to their microphones, they've had access to their cameras, they've had access to all of the personal information that we keep on our phones, at least that I know I keep on my phone. I don't want unvetted third-party developers to have access to the photos of my family that are on my phone and somehow hold those hostage. So I don't think it's as simple as just allowing it to open up and then ensuring that everything is going to go well. I think the representatives who have spoken previously are representing developers, not Mr. Reed, the proponents of the bill, representing developers who are certainly good actors, and they are not intending to do this. And by no means am I accusing them of that. But there are going to be exceptions to their rule, and that's not just hearsay. This occurs on a regular basis, and I don't think the state of Georgia should go out of its way to open up its citizens to additional cybersecurity threats.
All right, I'm not sure if we're speaking the same language here, but existing app owners that are on the system now are complaining about the 30% and the pay system that they have to go through with Apple. That's part of what I'm hearing. This is not the whole bill. So if Apple is restricting these apps from doing or developing or growing, why shouldn't that be regulated? I guess is the question I have. I mean, because what you're saying is all this about security and all that, and I get that with the apps that come on there, but what about the existing apps that have already been vetted? All they're wanting to do is lower their cost. That's
Sure.
what I'm looking at.
That's a fair point. So I do know that 30% is the industry standard across a number of online app stores. I know I can speak to TechNet's policy principles, which effectively act as our constitution. They guide the work that we do at the 50 state level. And under a service fees section, it specifically states TechNet opposes regulations that aim to cap or otherwise control technology companies' ability to price their own services in line with their business models. So just as much as I would not expect there to be legislation that intends to set the prices of a Fortnite skin, I think that the same standard applies here.
Representative Carpenter.
Yeah, so I mean, I think I understand what you're saying on the payment process piece, though. It's kind of absurd to see that you're able to process payments with Uber, Amazon, Facebook, all these other apps that are allowed to collect it outside of the realm of Apple Pay. And all of a sudden that's safe. But if we let all these other folks do it, it's not going to be safe. And I think do you see the dichotomy?
I'm not able to comment on the physical versus digital distribution policies. I honestly don't have that background.
But I mean, do you use Uber?
Not recently, no. but I have in the past, yes.
Yes, and so you're able to put your credit card information on the Uber app, and when you catch an Uber, you're able to pay for it outside of the Apple Pay platform if you so choose, and that seems to be safe. And I mean, so how is that safe? But all of a sudden, if Fortnite wants to sell a skin on the side, it's not safe. You know what I'm saying? I mean, it's just, I don't know, it's a stretch, I think.
Yeah, I guess it's to the extent that a platform is setting the terms and conditions of use of their platform, then that's what's allowable.
All right. Any other questions? All right, Representative Leverett, go ahead.
Thank you, Mr. Chairman. My name is Rob Leverett. I'm representative from Elberton, and I'm not tech savvy in any respect, so please bear with me. But I think if the concern that I've heard voiced against the bill is it would adversely impact the security that platforms are able to maintain on their platform. Is that a fair generalization?
Yes, sir.
So I think there are certain provisions in the bill that cause some concern with respect to that issue. Although I don't profess to completely understand them, I'm trying. But I don't see how some of these provisions on say restricting, making a developer use a certain platform and prohibiting them from selling on a different platform would necessarily affect the security of Apple's system, of Apple's platform, for example, just to use one of the platform managers.
Right. And again, my remarks were more about the app stores. I think that the individual components of the bill are certainly concerning as I broke them down. I do think that given the fact that, as one of the speakers before said, that it was their desire to see these filed in 50 states, that and that these have at least been introduced in a few, but none have moved yet, that their entire thrust of these bills is to open it up to third-party app stores, again, allowing them to go outside of the existing regulation or the existing infrastructure that's set up that does provide those security and privacy protections for the users. And then that's our biggest concern, is that by opening this up, it's not just going to be the good actors that you've had speak previously, but it is going to be folks that are going to take advantage of this to the detriment of Georgia consumers.
And thank you. And so is it, am I understanding then that the big security concern is not so much limiting where else the developer sells its product, it's at requiring the platform to accept certain apps or products on its platform?
That's the concern that I've addressed. Yes, I'm sure others have other concerns as well. But that is the concern that I've addressed. Yes, sir.
Okay, thank you. Thank you.
All right. Anyone else with a question? All right. Thank you, Mr. Edmondson.
Thank you.
And next we move to Carl Sabo. I hope I pronounced that correctly.
Close enough. I've just just had a birthday, and I've reached the point in my life where I'm not worried anymore. But thank you very much, everyone. My name is Carl Szabo. I am Vice President and General Counsel of NetChoice. I'm also an adjunct professor of internet law at the George Mason Antonin Scalia Law School. And I'm not going to talk about security stuff. Let's be clear what this bill is. This is a bill about interference with private contracts and interference with ongoing legislation. And anytime I hear billion-dollar corporations saying we need to level the playing field, I say hold on to your wallet. Now, Representative Reeves asked about ongoing litigation. Yes, there is ongoing litigation, a lot of it. I'll tell you one case in particular, Epic v. Apple. Epic decided to violate the terms of its contract. It knew it was going to do this because as soon as it voided its contract, and in doing so, Apple rightfully booted them off the store, Epic had ready to go the next day a lawsuit for injunctive relief. They'd hired Christine Varney from the Obama administration. They pumped a lot of money into this lawsuit. So they knew exactly the hornet's nest they were kicking. And now they want to send those bees into Georgia in the form of this legislation. Let's think about, there's been a lot of misconceptions about what is being charged here. If it were just a transaction fee, then these arguments might hold merit. Say, yeah, payment processing is only a couple percent. Why is it 30? Well, because you're ignoring a lot of what goes into that 30%. Let's suppose somebody decides to build a shopping mall. They build the structure, they build the roads, they do the advertising to customers, they hire security, they do all the infrastructure work, they get the shop set up, but they choose a unique business model. Instead of charging rent like you normally would at a shopping mall, they instead say, you know what? How about we do a commission-based service fee? Every time you sell a product, rather than paying an overhead rent on a monthly basis or a regular basis, you give us a service fee. Stores say, okay, that sounds great. If I have a down month, if I choose to not even sell a single product, then I don't owe that mall anything. Well, that's what you're seeing with Apple and Google. These are online malls that have adopted this business model. And that business model goes into the ongoing maintenance and development of that retail location. And once again, this cost exchange contract structure enables an overwhelming majority of the apps to be free. Because if we went to a classical structure where you had to pay rent on a monthly basis, then Georgia customers would start to see free apps go away. And we would balk if the government decided to interfere with that private agreement between a mall and shops, but that's exactly what we're doing here. The other thing that we're seeing is the government picking winners and losers. I mean, that's really what this is about. Let's be clear about who the founding members for the Coalition for App Fairness are. I heard the question try to be skated. It was a pretty direct question, one should be leaned into. Founding members were Spotify, Match Group, and Epic Games. Now, Spotify is the largest music streaming service on the planet. It currently has a market cap of over $58 billion. Match Group runs things like Tinder and OkCupid. They made over $17 billion last year alone. Or sorry, they have a market cap over $42 billion. Epic Games is one of the largest video game companies. They're a founding member of the Coalition for App Fairness, one of the chief proponents of this legislation. They made over $17 billion last year alone. And I would like to note, they charge a commission fee on their own store for in-app purchases, as well as apps that you download through that store. These are the founding members. And let's be clear, services like Match and Spotify, you don't need an app. You can open up the website, go to spotify.com right now and start streaming music from pretty much any device, and that includes your smartphone. Let's also look at the actual impact to Georgia consumers. As I said, this will ultimately increase cost to consumers. What you see sometimes is a loss leader service. Now, it was alluded to that, well, the reason we should exempt video game consoles is because they don't operate a loss leader program. Loss leaders are kind of like how Bic will give away the razor and then charge you on the razor blades. Well, if that were true, then I can't see how video game consoles aren't included. You can go to the store, you can go to Best Buy right now and go buy not the brand new Xbox, but an older Xbox, and Microsoft will make a profit on that. Nintendo has historically always sold their consoles at a profit. Same goes for Sony. So the argument that we need to exempt video game systems because they're not loss leaders just doesn't match the facts. But the other harm to consumers of Georgia is, once again, the way that we're removing the ability for these stores to make money on the services they provide. Ultimately, these service fees are much more than transaction fees. As I said, it's development of the mall, it's building the service, but it's also building the servers. So when you go and download an app, let's say you go and download the Spotify app today, you're not downloading from Spotify. You're downloading from servers that are bought, paid for, and provided by Apple or Google. You're using bandwidth that's not paid for by Spotify. You're using bandwidth that is paid for by Apple and Google. When you have a problem with your payment processing, you get on the horn and you're not talking to Spotify. You're talking to Apple and Google. So that's part of the other service fee that they charge, is for customer service. So at the end of the day, let's be 100% clear about what this legislation is going to do. It's an interference with contracts, which as a staunch conservative, I have a real issue with. And it's picking winners and losers. Because what we're saying right now is that multi-billion-dollar companies like Match and Epic should get more money than other multi-billion-dollar companies. And I'm sorry, that's not the role for government right now. That is the role for the private sector to figure out. And with that, I'm happy to answer any questions you may have on the ongoing legislation or the issues with regards to interference with private contracts or how these systems operate.
All right, does anyone have a question? Anyone online have a question?
I got a quick question.
Representative Carpenter.
Yeah. So do you happen to know who created the two folks that spoke before, right before you, that were obviously against the bill? Who's driving those associations? Do you know? Because you talked about my two speakers and who was driving. So do you happen to know who drives those two?
Well, what I can tell you is NetChoice. We list all of our members clearly and prominently on our website. I don't know if TechNet or the App Association do that, but I'm sure you can ask them and they'll be happy to answer those questions.
Yeah, I think I've researched. I think Apple and Google both have a lot to do with those two. So I think that argument that the two that spoke for me were just speaking on behalf of the other two. I think another quick question. I mean, you have a situation, right, where Apple is creating an unfair competitive advantage for Apple Views Music versus Spotify. And so how do you say the government can't pick winners and losers, but yet we're giving the power to Apple and Google to pick winners and losers? I think that at some point when that happens, it becomes a big issue to me personally.
So let's be clear that Spotify today is twice the size of Apple Music, twice the size of paid subscriptions of Apple Music. So if it were simply a price feature, then there would be, you would expect to see Apple Music being the most dominant, right? Lower cost, equal service. Apple should win that battle. But that's not what you're seeing. And why is that? Well, first of all, if you go and sign up today on Spotify.com, you will pay $10 a month, the same fee that Apple Music charges, and pretty much kind of now the standard fee across music subscription services, $10. If you subscribe through the Spotify app on Apple, you will pay $13. Why is that? 30% fee. So 30% of $10, $3, $13 is what you pay on Apple. So what you're not seeing is Spotify incur any financial harm from what Apple is charging. Because what are they doing? They're just passing that $3 down to the unwitting consumer. You could, of course, as I said, open up the website on your phone, go to Spotify.com, sign up right there on the same device, pay only $10 a month, and then just log in on your app. So when it comes to the comparison right there, I don't think it's quite, no pun intended, apples to apples. But by the same token, it's clear that Spotify seems to have a better service, a service that more and more consumers demand. And why is that? Because the number of subscribers is twice that of Apple. And this has been going on for a while. Now, one thing that's important to note is it's not as though this 30% fee came out of nowhere. This has been in place from the beginning of the App Store. And if the argument is, well, it's a monopoly, then you would have expected to see Apple continue to raise that 30% fee because there is a dearth of competition. That's what a monopolist does. You haven't seen that occur. What you have seen, in fact, is Apple recently made a change to lower some of its service fees to 15% for smaller app developers. That is actually antithetical to the actions of a monopolist. Now, if the concern is it a monopoly? Well, the good news is we have existing law today to address specifically that. It's the Sherman Act, and in particular, that can be taken and advanced by your state AG, as we've seen with the Georgia AG bringing lawsuits against some other tech platforms. So if the concern is monopoly, well, we have antitrust law, but that's not what we're seeing here. We're seeing prices and service fees remain constant, or decrease, which is antithetical to a monopolistic situation. And with respect to Spotify, they have twice the number of subscribers at a higher price. So they're clearly offering a better service. And that's really what we want people to do, is to compete on service.
Anything else? So somebody that's, well, if you're accusing Apple of stealing your product as a developer, is that your answer to that as well, that there's other statutes to control that?
100%. If there's intellectual property theft, we have copyright law, we have trademark law, we have patent law. We have a lot of legislation today to address that. It's a very serious accusation, and there are hundreds of lawyers across the country who make a pretty penny delving into the intellectual property issues. That's not what this legislation should do, because if somebody's stealing your theft, you go bring an intellectual property suit. That's the correct remedy for that action.
Okay. All right. We do have, we're at no other questions. All right. Thank you, sir.
Thank you.
All right. Is that all our speakers? All right. That was it, all the speakers.
Whew, we should have ordered lunch. I knew when I come in this room, I get stuck here for a long time.
All right. Well, I appreciate the input from all of the witnesses. We're not going to take a vote on this today. We'll bring it back up most likely later in the week. And as to House Bill 109, we're not going to have time to get into any meaningful discussion about it. So we're going to put that off to the next hearing as well. So thank you.
I appreciate you. I apologize for taking up so much time.
No, that's
guys.
okay.
I didn't know it was going to be that exciting.
It's mostly my fault.
That's all right.
And we're adjourned.